Good morning. Welcome to Best and Krieger's webinar titled Walking the Line, Public Agencies, Officials, and Employees' Roles in Local Elections. We will get started in just a few minutes. Before we begin, we have a few housekeeping items to go over. As a reminder, all attendees are in listen-only mode. If you have questions during the presentation, please use the chat box underneath the presentation slides to ask questions. Please feel free to ask questions throughout the webinar. However, the presenters may hold all questions until the end of the presentation to ensure we get through all of the material. This webinar is eligible for CLE credit. If you would like to obtain a CLE certificate, please email events@bbklaw.com after the webinar, and a certificate will be emailed to you. Again, that's events, E as in Victor, ENTS, @bbklaw.com. If you wish to view and or print the presentation materials, they can be found by clicking on the document folder in the lower right-hand corner of the webinar platform. Both the webinar recording and materials will be available on the BB&K website approximately 48 hours after the presentation. Thank you, and I will now turn the call over to BB&K attorney Jim Priest. Jim?
Thank you, Ashley. Good morning, everyone. My name is Jim Priest. I'm an attorney with Best and Krieger in the Municipal Practice Group. I am an election law specialist. I've been doing that for many years. Also specialize in areas of land use, tax assessment, fee setting, Prop 218, money issues, and those type of things. But today we'll be talking about various election issues, which are always very interesting. I'd like to introduce my partner, Sigrid Asmundson. She's joining us on the call as well. Sigrid?
Great. Thanks, Jim, and welcome, everyone. My name is Sigrid Asmundson. I'm also an attorney at Best and Krieger in our municipal law group. I serve as general and special counsel to cities, counties, and special districts throughout California. I also practice in the area of election law, both on the state and local level, assisting agencies with the initiatives, referendum, candidate process, election challenges, and FPPC investigations as they relate to elections. This presentation today is going to address the election concerns that public agencies and the public have right now and through the November election. I wanted to let you know that because we really aren't going to be going into the legalese of getting on the ballot. For most of you, that time has passed. It ended on August 10th, last Friday. So instead, this presentation is really focusing on what you are doing right now all the way through the November election, and it assumes that you have either measures or candidates on an upcoming election. The first thing I want to go into is ballot materials and elections, because for the majority of you, you are right in the middle of this right now. There are several types of ballot materials. For measures, there are three. There's the primary argument for and against the measure, there's the rebuttal arguments, and there's the impartial analysis. For people, there's the candidate statements. And I realize that for many of you, if you follow your county deadlines, some of these deadlines have already passed. However, I'm going to go through the details of what is required for each of these ballot materials, because for almost everyone, you are currently in that very small time period in which you can review and challenge any of these materials. If you go beyond that time period, you can no longer change it, and these will be printed on the voter information pamphlet. So it's important to know the basic requirements of what needs to be in these materials, so that you know whether or not you need to challenge them or change them. Starting off with the primary ballot measure arguments. So, basic requirements from election law are that there's no more than 5 signatures allowed per argument. If more than 5 are included, the elections official should only print the first 5 that are listed. The primary ballot argument can be no more than 300 words. Again, check your filing deadline. Some of you had a deadline of last Friday. I know that some have deadlines of this week. Also, charter cities that are hosting their own elections can have different deadlines. These deadlines are set by your individual elections officials. And the purpose of the primary ballot measure argument is so that voters have the benefits of having the pros and cons of a measure to assist in reaching an informed decision. That's why the legislature allowed them, and that's why they are in the voter information guide. So who may write primary arguments? Well, here are the statutory requirements, and then I'm going to tell you a little bit of how the courts have deviated from this. So for voter petition-driven measures, ones that have been circulated and obtained the requisite number of signatures, the proponents of the measure may prepare arguments in favor. Now, the courts have provided that the proponents get first dibs on this. The statutory language is a little vague about whether or not it's the proponents or other interested parties, but courts have said that really anyone can file arguments. But the legislative body is designated to prepare the arguments against. Again, the courts have said while the legislative body is the one designated, anyone could file a primary argument against. For city council measures, meaning the ones that are proposed by the city council and placed on the ballot, several people may file these primary arguments, specifically the legislative body as a whole or designated members of that body that are authorized by the legislative body in a meeting to draft those measures. Also, individual voters, a bona fide association of citizens, a combination of voters and associations who are bona fide sponsors or proponents of the measure. Now, what is a bona fide association of citizens? There's a very specific requirement for what is a bona fide association of citizens. They're required to provide a copy of something showing that they are this type of association. It can be articles of incorporation, it can be partnership documents, it can be letterhead containing the names of the organization. And in selecting an argument for a bona fide association, the city elections official shall not consider the type of document submitted, just simply that they have submitted that type of document. Now, if multiple arguments are submitted for a primary argument, the elections official needs to decide which one is being printed, and that is printed in a very specific order. For city council measures, the first priority is the legislative body's argument or arguments drafted by a member of the city council or legislative body that is authorized by the city council. Second is proponents of the measure. Third is the bona fide association of citizens. And fourth is individual voters. Now, this is important because whether or not a city council member is authorized to write it can really dictate the priority of their argument. If an elected official is authorized by their legislative body to write an argument, they get first priority. If they are not authorized by their legislative body to draft this, they fall all the way down to last priority as an individual voter. The fact that they have the title of a city council member does not matter unless they are authorized by the legislative body. There's nothing prohibiting a legislative body from authorizing one of its members to draft the for argument and another member to draft the argument against a measure. This can happen in cities or public agencies in which there is a split vote, maybe a 3-2 or a 4-1, in which some city council members are interested in placing the measure on the ballot and some are not. In those instances, then city council members may ask to draft the argument for and against. In saying that, you should not authorize the same person to draft both arguments. That seems very common sense, but that has been asked before. Different members need to be writing these arguments. Second type of ballot material is rebuttal arguments. Cities may actually choose whether or not to allow rebuttal arguments. If the city decides not to have rebuttal arguments, it can adopt in its resolution a provision saying that it is only going to allow arguments for and against, and that's all that will be printed in the voter information guide. However, if it does allow rebuttal arguments, once the primary arguments are submitted, the elections official will provide the argument for the measure to the author of the argument against, and vice versa. If there is no primary argument for or against a measure, no one can draft a rebuttal argument, meaning that the person who drafts the rebuttal argument must have been the author of one of the arguments. Additionally, if the rebuttal is not returned within 10 days of the filing deadline for the primary argument, then there is no rebuttal argument. Rebuttals are a little shorter than the arguments, no more than 250 words, and no more than 5 people may sign. There have been instances in which the 5 signers are a little bit different than the original argument. We do recommend that you always require that, as provided here, the author of the primary argument must be drafting the rebuttal argument. The impartial analysis. Again, I assume that a lot of you have already submitted this, but I want to go through this because it ties into the challenge period for these ballot materials. So the impartial analysis is prepared by the city attorney. The only time that it is not prepared by the city attorney is if the ballot measure impacts the organization or salaries of the office of the city attorney. The analysis should show that the measure's effects on existing law and the operation of the measure. It can and should note if a measure is being submitted that is illegal or unconstitutional. The purpose of the impartial analysis is to provide correct and substantive information. However, there have been instances in which an impartial analysis does fail to provide substantive information and has not been challenged. If that does occur, the courts have determined that an insufficient impartial analysis does not impact the overall effect of the measure and the electors vote on it. The impartial analysis should not exceed 500 words, and if the measure will not be printed in the voter information guide, the impartial analysis must note that to the reader where to obtain its copy, and that copy must be provided to a reader at no charge. The impartial analysis must have also provided whether the measure was voter-driven or proposed by the City Council. The last one is candidate statements. Candidate statements were submitted with nomination papers, and that statement must include the name, age, and occupation of the candidate, a brief description of the candidate's education and qualifications. However, candidate statements cannot reference other candidates, their character, qualifications, or activities. It cannot include party affiliation, membership, or activities in a partisan political organization. As noted, it must be submitted with the candidate's nomination papers, and it cannot contain false, slanderous, or libelous statements. There are additional costs regarding the candidate statements for printing and translating that we're not going to go into here, but just so that you know, candidate statements are generally paid for. If obtained by the legislative body, they are paid for by the candidates. So here's why I went into all those details. The public examination period is a very important period because this is the only time in which you may challenge the ballot materials. All ballot materials are subject to a 10-day public examination period immediately following the deadline for each set of materials. For example, for several of you, the deadline for the candidate statement, the impartial analysis, and the primary argument was last Friday, August 10th. Right now, we are in the public examination period for those 3 documents. This period is the only time the public may view this and file any kind of lawsuit to change the language in these materials. At this point, because the ballot materials have already been submitted, only a court may amend the ballot materials. This includes non-substantive changes. Any typos, anything that is just inaccurate in that ballot material, the elections officials should not be changing these ballot materials at this point. They can ask a court, or someone else can ask a court to change the ballot materials, but that is it. Additionally, a court will amend the ballot material if it finds by clear and convincing evidence that the material is false, misleading, or violates the elections code. So again, in challenging ballot materials, going into a little bit more depth, the public examination period is where you may either file a writ of mandate or injunction to remove language that is false, misleading, or inconsistent with any provision of the elections code. Now, inconsistent could mean for candidate statements, how I mentioned that candidate statements can't reference other candidates. That would be something that is inconsistent with the elections code. If a challenge is filed by a voter, the elections official is named as the respondent, and the author or candidate is named as real party in interest. The elections official may also file a challenge against ballot materials. If it is filed by an elections official, the County Board of Supervisors is named the respondent, and the author candidate is named the real party in interest. These are the only two methods in which you can challenge ballot materials. The City Council cannot file a challenge with city funds to challenge ballot materials. Only the elections official can. If an elected official desires to challenge ballot materials, he or she may do so under the first provision as an individual voter. For some of you, it is automatic that your city clerk or your district secretary is serving as your elections official. However, I recommend to always ensure that your resolutions do state who your elections official is and that it is a local member of your legislative body. In some instances, special districts particularly will designate the county as their elections official and have the county govern their entire election. When this occurs, if they have not reserved the title of elections official within their district, then only the county can file as the elections official under this provision. And in our experience, counties will generally not file a lawsuit on behalf of another entity. The elections official does have a duty to respond if a voter files a writ of mandate or injunction, but in many cases, the elections official will simply submit to the court and may submit to the court and provide that it will follow whatever the court's decision is, thereby allowing the real party in interest to argue. Ballot materials are official matter. It's important to remember this because these materials are printed in the voter information guide, and only official matter are printed in the voter information guide. Elections officials need to provide on the front cover heading of the first page of the voter information guide that arguments in support or opposition of the proposed laws are the opinions of the authors. It should be noted that authors of ballot material can be held financially liable for ballot materials that are libelous, false, misleading, or inconsistent with the Elections Code. There is no immunity from civil liability. So, for example, if a candidate is named as a real party in interest in a challenge against their candidate statement, they can be liable for false and misleading information provided in their candidate statement under the Private Attorney General statute, Code of Civil Procedure 1021.5. On the flip side, if someone challenges a candidate statement and that candidate defends their statement and is successful, then that candidate can recover fees for defending its own ballot material. The recovery of costs in these instances depend on three factors. One, whether it conferred a significant benefit to the public, whether two, it was necessary and financial burden of private enforcement to make the attorney fees necessary, and three, if the fees should not have been paid out of recovery, if any. Fees will not be awarded by a court if the changes are minor. So the private attorney general fee is generally only provided if there is egregiously false or misleading information, or perhaps if a candidate statement clearly names another candidate. Invalid ballot measures. What would you do if you believe an initiative or referendum is illegal or unconstitutional? And I won't go into too much detail about this, but I did want to note this, because what happens if a ballot measure is currently on the ballot and you believe it is illegal? Well, a city council can follow the procedures of the Elections Code and place the measure on the ballot. If they have done so, they can file a petition for writ of mandate against the elections official to remove the measure from the ballot. This is a pre-election challenge. The City Council could also wait to see what happens at the election, then file a post-election challenge to invalidate the measure. The same applies for an individual voter. An individual voter could right now file a petition for writ of mandate to request that the election official remove it, or they can wait until post-election to do so. I want to briefly go into the role of the city clerk and the role of city attorney. Starting off with the role of the city clerk. The city clerk is the elections official. They are charged with providing fair and impartial administration of elections. They're the ref. They review the petitions, notices, and other election filings for compliance with the Elections Code. That's it. With rare exceptions, There are no discretionary calls. This is ministerial action only. There are certain exceptions that are enumerated in the Elections Code. For example, some of you may be dealing with ballot designations right now. That is an instance when the elections official has significantly more discretion of what is and is not a ballot designation. However, in all other instances, even if the city clerk or elections official believes that something is wrong based on information that they have received outside of that petition, they have a duty to accept the filing if that filing complies with the Elections Code. And then thereafter could challenge it and bring in evidence. So how much advice can the elections official give to the public? Well, they can provide basic guidance, generally only refer to the Elections Code. They cannot provide substantive legal advice. They have no legal authority to proof a candidate or proponent's work before filing. This frequently happens. You will receive ballot materials or measures, and they will ask you to review this. We recommend not doing so and always providing that they should contact their legal counsel. City officials are treated the same in their roles as candidates or proponents. For example, if a city official comes in and asks the city clerk for advice, the city clerk cannot provide any more advice to that city official than they could to any other person. And again, the elections official should always state when giving advice that it cannot give legal advice and recommend that the questioner consult their attorney. Case law protects the elections official from incorrect information when this statement is made. The role of the city attorney is to help the ref in applying the Elections Code. With city measures, the city attorney prepares the impartial title and summary and the impartial analysis. So how much advice can the city attorney give to the public? Well, not much. They should not provide any more information to the public than they should to any other member of, for example, a candidate or a proponent. So what about elections advice to the city official? The city official should note that the city attorney is a public resource, meaning they are public funds. A city official should not use them in a way that advocates for or against the measure and should be wary of using this public resource. They should use it as a member of the private. The city attorney must always ask, and city officials must always ask, if the question is being asked in the official capacity of that city official or as a candidate or proponent or member of the public. If it's being asked as a candidate proponent, would the city attorney be giving the same type of answer to any other candidate proponent if asked? If the answer is no, then the city attorney should tell that city official that they cannot provide this information. In some instances, the city attorney will also defend the elections official in ballot measure challenges. Now, Jim is going to go into the role and responsibilities of officials and employees. So, Jim?
Thank you, Sigrid. Thank you, everyone, for attending the call. As Sigrid was already touching on this issue of use of public funds, public resources to advocate versus information, we've already been talking about what happens when somebody asks the city attorney or city clerk for assistance. What do you do there? And as she mentioned, if it's a basic questions or something like that, it's one thing, but it cannot be a big help to a candidate or something, because that would be government-funded advocacy. So we get into the distinctions here a bit more. The main laws governing this are Government Code 54964. I won't quote the whole thing, but the keys are it's got to be an officer, employee, or consultant. A city consultant can also direct the spending of public funds and potentially get the city into an issue here. So it's not just officers, it's not just employees. And may not expend or authorize the expenditure of any funds. And expenditure is defined very specifically in the statute for express advocacy for or against a ballot measure or a candidate. So the statutory definition is more narrowly confined to spending public funds for something that actually says, vote on Measure A, vote for John Smith for mayor. Now, there is an exception in 54964 for informational activities, public funding of informational activities, letting the public know possible effects of a ballot measure on the local agency, those type of things. As long as it's not prohibited by the state law or the Constitution, and as long as it's fair, impartial presentation that is accurate of the relevant facts. And obviously, you know, we can get into a lot of nuance over that, but that's the general statutory rule that prohibits government funding for advocacy. But of course, the courts couldn't leave well enough alone, and 54964 is not the final authority on the subject. We also have two significant California Supreme Court cases that you may be familiar with, Stanton v. Mott and Vargas v. Salinas. And the thrust of those cases is that while 54964 covers express advocacy and prohibits using government funding for that, the Stanton and Vargas cases blur that line considerably. Rather than just does it expressly advocate or not, now you look at the style, tenor, and timing of the material to decide whether it's advocacy or not. The Vargas case made clear that both standards apply. One of the issues in that case concerned it was a utility tax repeal in the case of Vargas, and what the city was doing was putting out information in the form of staff reports, posting things on their website, discussing it in public meetings, that, you know, these are the effects if the utility tax is repealed in our city. These are the financial effects. It was presented in a neutral, impartial way. However, somebody sued on that, claiming that even putting out that information was effectively advocacy based on its style, tenor, and timing. The court came back and said no. One of the things the city argued is, well, the material we put out didn't say anywhere, you know, vote against the utility tax repeal or vote for this. It didn't have anything explicit in there. It was just stuff we put out there. The court said that while it was informational, you still look at the style, tenor, and timing. So, I mean, that was the big thrust of the Vargas case, is both standards apply. So even if you have government-funded material that doesn't expressly advocate, it can still legally be advocacy if it's the style, tenor, and timing indicate that. We also have Government Code 8314. And that's actually it's a civil penalty statute. It's not technically a criminal statute, but what it does is it prohibits an elected state or local officer, including an appointee, employee, or a consultant. Again, consultants can do this too, to permit the spending of public resources for a campaign activity or for personal or other purposes not authorized by law. The statute defines public resources very broadly. Any agency-owned property, asset, land, buildings, facilities, agency-compensated time, and we're going to get into that a little bit more relative to public employees doing campaign activities. But again, 8314 prohibits using any of these public resources for campaign activity. The definition of use, got to be substantial enough to result in a gain or advantage to the user and a loss to the agency. If somebody made one political phone call from a city phone, and we're talking, you know, 2 cents of resources here, that probably won't be found as a violation under Government Code 8314. It's just de minimis there. However, you know, if a substantial amount of resources are being used for some sort of a campaign activity, for some form of advocacy, you may have a violation of 8314. And consistent with what we have with 54964 and with Stanton and Vargas, there's also an exception in 8314 for providing fair and impartial information about the effects of a measure. So again, we get back to that, is the style, tenor, and timing such that it is informational and not advocacy. And again, you know, that line can get a little blurry sometimes. We've got some case law you know, guidance on that, but, you know, it does still tend to be kind of a case-by-case determination here. Penalties for impermissible activities. Stanton and Vargas, the public official who authorized the expenditure is personally liable if they fail to exercise due care. And that means, you know, using reasonable diligence and finding out whether, in fact, it was, you know, a legitimate expenditure or not, as opposed to just, spend it and I didn't even check into it. If there is a Stanton or Vargas violation, the plaintiff who sues can receive attorney's fees, and that can be assessed directly against the public official. Again, you got to look at the facts of each case to see, what could end up going on there. Government Code 8314, there's a civil action possible, penalty of up to $1,000 a day per violation times 3 times the value of the unlawful use. Obviously, if this is a small thing, that's one thing. If you're talking a large expenditure, that could be a substantial penalty. Another possibility, it's pretty rare except in egregious circumstances, there is Penal Code 424, felony misappropriation of public funds. And while, again, it's rarely used, it has been used on occasion for very egregious cases. I'm not going to go into all of these, but we're providing you sort of the general laundry list of permissible activities, and the next slide we'll talk about impermissible activities. These are the informational versus advocacy efforts based on style, tenor, and timing that the courts have at least so far been able to distill down to us. Permissible activities include preparation of an initiative, the staff work, the legal work that goes into writing the resolutions, the ordinances, the notices, the staff reports. That's okay. There's case law that says that that's all right. Just the regular staff work to bring it to the council for a decision is okay. Identifying program services to be cut if a measure passes and posting those reports or minutes on the city's website as standard practice. That was the Vargas case I just mentioned, and the court said that's okay. Including informational, nonpartisan articles in a regularly published newsletter. And I'm highlighting that because this is an issue we run into fairly frequently. You have an election consultant that the city hires, and the election consultant gets in there and gets all excited and says, all right, we have a whole plan, here's how we're going to market this measure. And oftentimes, they will propose special mailers, dear neighbor, dear taxpayer, dear resident letters that purport to put out impartial information about a measure, but it's put out as a special mailer. It's not part of the city's quarterly newsletter, monthly newsletter. It's paid for and sent out special delivery to voters, specifically things you should know about Measure D, things you should know about Measure C. There are FPPC regulations on that. There's also a case called Peninsula Guardians versus Peninsula Healthcare District that clearly indicate if it's part of a regularly published newsletter, you can do it, if it's informational. But if you're sending out special mailers outside of that regular form of communication, you may have a problem there. Even though the language itself may be deemed impartial, it's considered an advocacy effort, and so you got to be careful with that stuff. The city can author ballot arguments for or against the measure. We've already talked about that. That's not an impermissible activity. Prior to the measure being placed on the ballot, the city council could state on the record its position regarding the measure at a regularly scheduled public meeting where alternative viewpoints may be discussed. After the measure is on the ballot, we typically advise that the city council should no longer be having staff prepare agendas, reports, etc., in order to put on the record the position. So it's kind of a nuanced issue there. There's some other ones here: factually inform the public in an informational matter. Again, we talked about that a bit. There are a few other items here that are permissible. The case law allows that. Sorry, having trouble with my slide here. There we go. Then we get to impermissible activities, and the Stanton and Vargas case both really get into this. Bumper stickers, posters, floats, TV, radio ads, those are out of bounds if they're publicly funded. Campaign literature prepared by private proponents of a measure and then giving it to city staff and saying, hey, you guys disseminate it. That's not allowed either. Advocating a yes or a no vote in materials. Again, that violates Stanton Vargas. That's probably express advocacy and would violate 54964 as well. Contributing to campaigns, supporting or opposing a measure. Again, public funds cannot be used for that. Printing, promotional materials, using office supplies for that, same issue. If they're promotional, again, if they're informational and style, tenor, and timing are kosher, then you may be able to expend public funds. But if it's promotional, it's clearly pushing the measure, then that's going to be a problem. And then using city staff or employees to campaign during work hours. We're going to get into that in more detail in a moment. Use of private funds and private time in elections. We get into a big distinction here, and again, we'll talk about that more in a moment. If it's private money, and if it's your private time, it's not on city time or city resources, generally no limit, First Amendment speech. You have freedom of association as a citizen to go out there and meet with people and advocate all you want. I mean, it's just a constitutional right there. But officials need to be mindful of private versus public time. If you're the mayor and you're in favor of a measure and you want to go out and give stump speeches and you want to push that all you want, that's fine. Just have to be mindful of what's on your private time, what's using personal funds, what's using campaign funds, as opposed to what's using city funds and city resources. Sorry, I sort of jumped ahead to the next bullet point there. But yeah, private funds can include personal money, can also include valid, privately contributed, and spent campaign funds. Now, there may be some FPPC requirements there. You may have to file paperwork to establish a committee. There actually is a classification of a type of committee to support or oppose measures. So there are regs for that. I would suggest that you consult those if you intend to form one of these organizations in order to support or oppose a measure. Okay, now we get into campaigning by public officers and employees. And again, we get into this distinction of what's on government time, what's on private time. During work hours, public officers and employees may not engage in political activities. So what are work hours? Typically, your standard or overtime hours that are part of a required work shift. It's not it's not a lunch break, vacation, admin leave, or a public holiday. Usually, it's a work hour on a public holiday if, in fact, you are working. If you are a police officer and you're working on July 4th, you're working. You're on city time. So the fact that it's a public holiday doesn't free you up to go out and advocate while you're on the clock. It's got to be work hours or non-work hours. And then we've got a list here, and again, there's some case law out there of on work hours what you may and may not do. No distributing pamphlets, papers, attending campaign meetings, making phone calls. That's one we run into a fair amount, is somebody who is sitting there on city time, but they use their private phone and they're starting to make political calls, and they got their feet kicked up on the desk, and we're explaining that, well, you're still on city time. You know, wait till your break or wait till you're off shift or something. Or any other campaign tasks. This is one that we run into occasionally too, are people that show up to work and they're wearing hats, shirts, buttons, and stuff. And typically we advise, don't do that. You're on city time. Don't be a walking advertisement for the measure. An officer or an employee may solicit or receive contributions to promote the passage or defeat that affects rate of pay, work hours, retirement, civil service. So again, they're limited to off-work hours, and the city can prohibit this solicitation on city property, but officers and employees do have the right to take political action when it specifically concerns those issues. Appearance in uniform and/or vehicles and equipment. Government Code 3206 prohibits officers or employees from participating in political activities of any kind while in uniform. Obviously, we tend to run into this most often with our police and fire officers. The question often becomes, what's in uniform? If I'm a police officer, I get that I can't walk around in my Class A dress blues and start, campaigning on a measure. However, what if I'm walking around in a pair of brown khaki pants and I've got a golf shirt that's paid for by the Police Officers Association with purely private funds? Can I walk around the city then? I'm off work hours. Can I go campaign? The question becomes, is the clothing or equipment required for the job? I would say your dress blues, if you're a police officer, yeah, that's required for the job. So that's in uniform. Your khaki pants with your golf shirt that's paid for privately, if that's not required for the job, and if it's not paid for by the city, you could probably wear that. Is the clothing equipment associated with a specific position? Now, where this comes up frequently is, again, with police officers. They're walking around with their khaki pants and their golf shirt on, and they got that big, fat police badge sitting right there on their waist. And then they're getting photographed with candidates all over the town, in support of the candidate. Our advice is typically no badge. I mean, of a police uniform, there's probably nothing more specifically associated with that position than the badge. So our advice is no badges, nothing that's obviously associated with that specific position. This rule also applies even when a uniformed officer or employee is off duty. So again, no appearing in uniform at any time for any political activity there. We get into this next bullet point is kind of tricky. No authorizing an officer or employer or candidate to appear in, on, next to, or otherwise appear to operate agency vehicles or equipment for political activities. We had one a little while ago where we had a candidate who was running for office and claimed, I support fire. There was a fire truck just parked out on the street, and he just walks up in public view and has his friends shoot photos in front of the fire truck. I don't think there's anything illegal about that if you're just taking a picture right there. To the extent that you're misappropriating any logos or something that are on the fire truck, there may be something there under a city's particular municipal code. However, there's nothing against the government code that prohibits just standing in front of City Hall and shooting a photo and using that in your ads. But if they're calling you up and saying, hey, can I sit in the fire truck and look really cool for this political ad, that you have to decline. Next slide, my favorite. Government Code 3204. Basically, a public officer or employee can't buy votes or contributions from other officers or employees with promises of gifts, money, promotions, jobs, or any other compensation. Pretty self-explanatory rule there. Government Code 3205. Public officer or employee shall not directly or indirectly, so you can't use intermediaries, solicit political contributions from another officer or an employee. And that applies to all solicitations, even outside of city property. So if I'm an incumbent mayor and I'm meeting with a department head off-site, non-work hours, and I go, hey, can you contribute some money to my campaign? Doesn't matter if we're on property or if we're outside of city property or not, can't do it. The one exception is if this officer or employee is soliciting contributions from a significant segment of the public. So if I'm sending out a campaign mailer to 1,000 people in my town soliciting contributions, and 1 or 2 city employees happen to be included in that, that's not a problem because there was no specific targeting of the officer or the employee. But, if the mayor's coming up to that specific person saying, hey, can I have some contributions or something, that's a problem. And violation of that is a criminal misdemeanor. So here's another interesting issue. Statements about candidates or measures during public meetings. There's a huge temptation politically on elected officials, sometimes appointed officials, to get up there on the dais and use the bully pulpit to push a candidate or to push a measure, and there are limits to that. Public officials may generally urge citizens to be informed and to vote. That's perfectly fine. You can do that at every meeting if you'd like, because that doesn't really push one way or the other on a measure or candidate. Public officials can also provide impartial, non-advocacy information to the public about a measure. So again, kind of like in the Vargas case, they had multiple council meetings and there were staff reports and there was data presented in an impartial, non-advocacy way about the measure, and that was okay. But public officials may not make advocacy statements about a specific measure. If you get up on the dais and then go, vote for Measure C, we advise against doing that. That's government-funded advocacy. Now, if you have a very brief comment, 15 or 20 seconds, that would probably likely be viewed as de minimis, probably not a violation there. If there is, it's a technical violation. There's really not much, substance behind that. But extended comments or statements would be prohibited government-funded advocacy. I've run into that a few times. I had a guy a couple years ago who got up there and literally went on a 30-minute diatribe from the dais about all the wonderful things this measure was going to do. And afterwards, I told him, I said, you shouldn't have done that. And he said, well, somebody sues me, whatever. And kind of a difficult situation there. But our advice is no, do not do it. And if you're going to do it very briefly and get off the issue. Don't go into a long recitation because you're really crossing the line into government-funded advocacy. And then public officials may not make advocacy statements about a specific candidate. There's no legal authority for that. If the mayor gets up there and starts saying, vote for candidate so-and-so, that just needs to stop. There's just no legal authority for that. Hypothetical question. Mayor Jones is running for another term this November. He rents out the city's community center for a campaign fundraiser and a rally. Community center is available for rent to the general public at a standard rate. Mayor Jones pays the standard rate and otherwise agrees to follow the city's standard conditions in using the community center. May he use the community center for this purpose? Well, in a vacuum, the answer would probably be yes. As long as there's no city policy prohibiting it, they could probably do that. It's not a violation of Government Code 8314 if the mayor is paying the same rental like any other member of the public would pay, then there is no advantage to him and disadvantage to the city over any other renter. And so, they'd be able to do it. However, Government Code Section 3207B allows a city to establish rules and regulations to prohibit or otherwise restrict political activities on the premises of the local agency. We had one a few years ago where candidates were basically driving the seniors at the community center nuts because they were constantly coming in there and campaigning effectively, and the seniors didn't like it, and the seniors went to the city administration, asked what we could do, and the city adopted a policy that says no more campaigning at the community center or at other city facilities, and that's legally valid. You can also adopt rules and regulations to prohibit or restrict officers and employees from engaging in political activity during work hours. That's usually something you put into the policy anyway, but in most cases, state law and case law govern that. It's just the policy would reduce it to a local document. Political signs. Actually, I'm going to jump the bullets for a second. The right to campaign in traditional public fora. While Government Code 3207 allows the city to prohibit political activities on the premises of the local agency, it may not quite reach to everything. It would reach to your community center, it could reach to your city hall, it could reach to various other brick and mortar city facilities where you would prohibit political activities. But things like parks, sidewalks, things that are what we call in the law traditional public fora, people may still have a constitutional right to engage in political activities on those city facilities. So there may be limits to what you can do under 3207. Jumping back to political signs, Reed v. Gilbert, I'm going to talk to this just for 2 seconds because we could spend an hour just talking about political signs. Reed v. Gilbert is a U.S. Supreme Court case, came out a few years ago. The town of Gilbert, Arizona basically has different rules for political signs versus directional signs versus ideological signs, like no war or preach peace or something like that. Different durational times. You could keep some up longer than others. You had to remove some sooner than others. It was kind of all over the map. The Supreme Court said that's content-based. You can't do that here. And so all I'm doing is mentioning Reed v. Gilbert. If you end up with a political sign issue, I would suggest that you consult with your legal counsel and just make sure that your political sign ordinance is up to snuff and not setting different rules for different kinds of signs, because that could be problematic. And then we get to the new mass mailing rule that came out last year. I'm sure most of you are familiar with the general mass mailing rule under state law and the FPPC regs. If you're sending out more than 200 tangible mailings at public expense that cost more than $50 and it features an individual official prominently, you may have a mass mailing issue here. Now, the mass mailing rule has a number of exceptions in them, putting names of elected officials on an agenda announcement or something. Those kind of things, there's exceptions for, and so it doesn't become a prohibited mass mailing. However, there was recent legislation passed because you had a supervisor down in Orange County who was kind of abusing the privilege here a little bit. And as a result, within 60 days of elections, 3 of these exceptions get taken out. So normally, letterhead with the incumbent candidate's name, you could send that out at any time back under the old rule, and that was not a prohibited mass mailing. Now, if it's within 60 days of an election, you can't have letterhead with the incumbent candidate's name on it. The next 2 bullet points are really the ones where the Orange County case highlighted the issue and why this rule was put into place. The supervisor, as I recall, would put out just announcements of meetings. He was just meeting everybody. And then we're having city events, and we're doing that. And by the way, I'm supervisor so-and-so. And so what they did is these meeting announcements that are directly related to the incumbent's duties and held or attended by the incumbent, and then announcements of a city event that includes these incumbents' names, those are out. You cannot, those are prohibited mass mailings in the last 60 days before an election. The rules are pretty detailed and pretty nuanced there, but we want to make you aware of the fact that they are out there. And so there you have that. And thank you all for listening and attending. I guess at this point, Sigrid, are we going to try to go through some of the questions?
Why don't I go ahead and answer the first 3 questions that were from my section of the presentation, and then you can answer the other ones. I saw quite a few questions here. So I'll start out with Megan's question regarding whether our council authorized 2 council members to draft the primary and 2 council members to draft the rebuttal. Is this not allowed? So as mentioned, the rebuttal argument is supposed to be drafted by the authors of the primary argument. However, there's also a provision in the Elections Code that provides that the authors of the primary argument may designate in writing other persons to draft the rebuttal. You noted that this was done by resolution, so it was done in writing, a designation for other authors to be doing the rebuttal. So you're fine with that one. Carrie asked, just confirming that a charter city can set its own deadlines. Yes, this is correct. If it is in the charter or their rules, then they can go ahead and do a different time period for the 10-day review.
If I could just mention one thing on that, Sigrid, really quickly. Sure. Yeah, charter cities can set their own deadlines for that stuff. However, you have that full freedom if you're running a standalone election as a charter city. If you're consolidating with the county, you're going to need to work that out with the county. Because even if you're a charter city or not, the county is going to say, our deadlines because we're consolidated, and as many of you probably know, the way the law is shaping up, it's kind of moving everybody toward consolidating with the statewide elections anyway. So just be aware of that. Technically, yeah, Charter City can set different timelines, but there may be that county coordination issue.
Mm-hmm. And then, Carrie, you also asked if a candidate statement includes prohibited information such as reference to another candidate, must the city clerk still accept it and place it up for 10-day public review? No. In that instance, if it contains prohibited information that is prohibited specifically by the Elections Code, then you can reject that candidate statement. For example, Elections Code 13308 prohibits any reference to another candidate in the candidate statement. Additionally, 13307 prohibits any party affiliation in a candidate statement. So you can reject either of those on the basis of the Elections Code, and that's in your ministerial duty. And then, Yvonne, you had a question that I may have answered earlier for Megan. Could you say that the author of a council-initiated ballot measure must also sign the rebuttal, or can it be different members of the city council? So, again, the requirement is that the author or majority of the authors of the primary argument must sign the rebuttal argument, or they must designate another member in writing to sign that rebuttal argument. And then the rest of these questions, there are quite a few, are on your section, Jim. Starting with Lewis.
Okay, I will try to get through as many of these as I can. Lewis asked, there are specific words that cannot be used in materials, correct? Like vote for, against? Well, again, yeah, I mean, if they're express advocacy language, like vote for, vote against, I'm for, or you should be in favor, absolutely. Where it gets a little trickier is when people use certain words in a purported informational piece. One of the ones that I run into frequently is it will be sent out as an informational mailer, but it will have things like a tax measure. It'll say taxpayer protections to save critical city services, things like that. When you start using loaded language like that, you quickly turn an informational mailer into an advocacy piece, and so you got to be really careful about your wording there. I can't give you, black and white on every single piece of verbiage, but, definitely consult with your legal counsel on that to make sure your wording is carefully chosen there.
Jim, I can also pop on really fast. The FPPC has said it very specific words as well. That might be what you're looking for. The vote for, elect, support, cast your ballot, vote against, defeat, reject, or sign petitions for have all been identified by the FPPC as trigger words. Right.
Let's see, Cynthia, if a trustee uses a district-provided cell phone to campaign or answer questions, is that allowed? Well, if the trustee is using the district-provided cell phone to carry out his or her duties as a trustee, that's one thing. If the trustee is calling to push the measure or to push his or her own candidacy or somebody else's candidacy, that could be a problem. Now, obviously, that's a question of proof at that point. But again, there's that distinction there. And you got to be careful using district-provided or city-provided equipment and know what role you're using it in. Let's see here. I've got one. We have an incumbent running for city council. This is from Joanne. We have an incumbent running for city council. He asked an employee for pictures the city has of him and photos of city events. We did not ask him why he wanted them or what he was going to use them for, but we can surmise he will use these photos for his campaign. Should we refuse his request? That's a tricky one. I mean, the costs have already been spent by the city here. It sounds to me like if you just give him copies of this, there's not going to be additional funds spent. I presume that it was for a valid city purpose when these photos were shot way back when. So there may not be, it may be one of those where it could be a technical violation, but there's really no penalty or damages involved. That's a tricky one. I would probably say no to be safe on that one, just because, we work on two levels in this profession, legal and political, and even if something may be technically just on the right side of the line or something, you could also get into a lot of political hot water for this. So usually in these cases, I advise no. Melissa asked, are there any limitations on employees supporting a campaign through their unions? Could a city employee union use city, oops, hold up. My picture just went down. Here we go. Could an employee union use city mail and space to strategize regarding a ballot measure, for example? An employee with his or her own public funds or private funds could support a campaign through a union. A union is a private organization. They often operate kind of like a PAC or a political group. And a city employee could certainly, pay his or her own private funds to that union and support them. Could an employee union use city email and space to strategize regarding a ballot measure, for example? There was a court case, Sigrid, do you remember? It was a school district case, and I remember you had the school district union that was putting material in the little mailboxes for each of the teachers. I'm trying to remember what that, maybe that's one, Melissa, you would ask that question. Maybe you could send me an email and we can talk about that offline because we're getting short on time now. Let's see. David Gassaway, how are you doing, David? Are there restrictions on a public agency funding a 501c4, even if that welfare organization is funding PAC activities? Oh, well, that's a question that would take about 3 levels to unpack. Because the question, first of all, is can the 501c4 fund PAC activities? There's a whole tricky issue there. And then secondly, even if it can, I don't know that the public agency can really fund that 501c4 for advocacy activities. But again, I think that's a more complicated issue. David, why don't you shoot me an email and we can talk offline on that one. What about elected officials and city paid for shirts? Again, I don't know if that's technically a uniform issue under 3206, or I'm sorry, 3205, but I would probably steer away from that. Again, it just looks like, your city is paying for like bumper stickers and things like that. Let's see. Ray, advocacy statements at the dais. What about the fact that the council can take a position on a measure? Yeah, if the council is going to call a measure, say, that evening, the council could also adopt a resolution or something saying, we are in favor of this, or, we're against this. We have to put it on the ballot because the proponents got their 10% initiative signatures, but we are making this statement that we're against it. They could do that, but once the measure is called, we recommend that you not make those statements from the dais. And you certainly don't agendize a formal action at that point. That would likely violate Government Code 54964. Because now you've got a statement that's expressly making an advocacy statement, and now you have a measure that's been called. Let's see. Oh, Dean Durlip. Can you reference the case that provides that purely objective informational material cannot be distributed in a special mailer or outside a routine newsletter? Peninsula Guardians versus Peninsula Healthcare District, 2011 case, as I recall. I don't remember the site, but that's the name of the case. And that talks about, the other place to look are in the FPPC regs. Dean, if you shoot me a quick email, I can shoot you the FPPC regs that talk about, special mailers as opposed to regular routine communication. Let's see. Oh, there's a ton of questions. I don't know I'll be able to get to them all. Let me try to do maybe one more, and then I think we're going to have to let you go. Police chief is authorized to use city-owned car for city and personal use. I assume that's an unmarked car. Chief stops at campaign event on way home after work, not in uniform, but parks city-owned car at event location. okay, de minimis use of public funds. I would guess that it's a de minimis use, unless he's driving, 4 hours across the state with that car to attend the event. If he's just going across town, I think that would be considered de minimis. Also, I'm making the assumption it's an unmarked car. If it is, then I don't know if there's any cachet in that car being present as opposed to a black and white with lights and all that. At the end of the day, I think it's de minimis. I mean, it's the value of driving it across town, and I don't think you're going to have a problem there.
Jim, you skipped Jennifer's question. Is there an analogy to Government Code 3207B for counties? Jennifer, 3207B does apply to counties. That entire statute is cities or counties.
Thanks, Sigrid. I actually went over that one. Does a legislative body have to allow non-incumbent candidates to promote their candidacy during business from the floor at a regular council meeting? Yeah, that's a little bit, I mean, somebody can get up there during public comment and pretty much promote anything. So if you give them their 3 minutes, 5 minutes, and they want to say, I'm the best candidate in the world, they can do that. And you let them have their public comment, and then they're done. There's really not anything you can do to control that. Let's see. Can you refer us to the correct mass mailing, government, or other code in the state law? Yeah, that's from Mary. Mary, again, why don't you send me an email, and I can answer you on that one. Let's see, Dean Derleth. We already answered that one about people, pushing measures or candidates during public comment. I don't know if you can stop them on that. Do you know the bill numbers for the new mass mailing rules? I could dig that up. That's Lucinda Williams. Lucinda, why don't you send me an email and I can get that to you?
It's SB 45.
SB 45? Thank you, Sigrid. Is there any legal restriction on a public official's ability to sign a ballot argument using his or her official title? None that I'm aware of. I think you can say, Mayor Steve Jones as author of the argument. There's no rule I'm aware of that prohibits putting a title. Anything you're aware of, Sigrid?
Using his or her official title, not unless you have a local regulation. There's no state prohibition, but some local agencies are prohibiting it in their own codes.
Oh, okay. Okay. I'm so sorry. The questions just go on and on here. And I think we're pretty much out of time. Yeah, we're over our time now, unfortunately. If you guys have any other questions, or I haven't gotten to them, or Sigrid hasn't got to them, we apologize, just the press of time. Feel free to email us, and we're happy to continue this discussion offline. But everyone, thank you so much for attending today. Sigrid, did you have any last words?
I don't. Thank you for attending. Our information is on the last slide. If you have any questions, we're happy to answer them by email or phone.
All right. Thank you all very much.
Thank you, and that concludes today's webinar. Again, if you would like an MCLE certificate, please email events, E, V as in Victor, ENTS @bbklaw.com. Thank you so much and have a wonderful day.